I'd like to thank Judy Saylor from Prime Point for doing the next presentation for us, talking about some of the challenges we're facing with the COVID as it relates to family medical leave and all the other fun stuff as our employees try to figure out how not to work. How do we figure out how to get them to work? That kind of stuff. So it's good stuff. Great information that helped us out a lot. So I'll turn it over to Judy. Thank you.
Thank you. Good afternoon, everyone. I hope you're enjoying the conference. I hope you're getting lots out of it. Please ask questions, because that's the only way we all get to moving this boat forward together. So today we're going to look at a few topics that are going on in our current news cycle. We're going to cycle back to New Jersey paid sick leave. There have been some updates to this. We will go over the Equal Pay Act. There has been, a few updates on that, not as many. We're going to look at the tax withholding bill that came forth just recently. And then I put all these other under COVID because we're going to look at leave laws, workman's compensation, and the new bill that has been passed for that, and managing your staff in this current new norm that we have. So New Jersey sick leave had a pretty big update in January, and lots of us really weren't attuned to it because it was year end, it was ACA season, but there are a few things that yourselves as government groups might need to have in your arsenal and be prepared for. The new standard with the update is that any PTO time that an employee has can be utilized for the sick leave purposes, not just 40 hours of that. I know lots of organizations decided to carve out the 40 and assume that that was going to protect them. The new standard as of January 6th says that all of that PTO time is potentially up for grabs if they are going to go out for one of the 5 reasons represented in New Jersey sick leave. Your plans must meet or exceed, which many of you are clients of ours. I am well aware that most of you do meet and exceed, especially when it comes to your union contracts. Employers are prohibited from requiring an employee to utilize the earned sick time. They can choose not to. However, they're still only going to be allowed to carry 40 hours over. And if you do not have a PTO bank and you call something earned sick leave, they'd only be able to use 40 in a year. Interns and temporary employees are eligible to receive this time. Many of you can recall when we were all discussing New Jersey sick leave, we talked about your seasonal staff. Those summer folks who come in May or June and work through potentially Labor Day, depending on what your programs are. I don't think this year is going to be an issue, but for the future, when those folks come in May, that clock starts. If you take them to September, that clock will quote unquote close. However, if you bring them in at Thanksgiving to help with the program, or you bring them in to do odds and ends work, that keeps the clock active. And they could get into the following year prior to the summer season and be eligible to utilize all of the hours that they have accrued for New Jersey sick leave. Employers who do not clearly communicate what is going on cannot penalize their staff for utilizing New Jersey sick leave. If they say to you, I'm going to use this as New Jersey sick leave, and you haven't communicated via in writing, in your personnel policy, in your intranet, in your employee experience, you're going to potentially be held liable for that with the states, as well as anybody that the employer chooses to get on their side. All requests by employees are presumptively valid. If someone says to you, I'm sick, I have to go to a doctor's appointment, I have to, be at my school, my child's teacher is requesting me being there, you have to assume that it is a valid issue and that they are eligible to utilize that. Now, as we recall, you can request documentation to prove what they were out for, but presumptively valid is going to be a big issue as we go forward with our COVID environment for now. The benefit year has changed slightly. It is a period of 12 consecutive months. The recommendation is not to change your benefit year. If you've already set it, which I feel like 80 to 90% of you are on a January to December. Don't try changing things. Stick to what you are currently doing and leave it at that. This would be for organizations who potentially amp up and get larger and need to identify something as New Jersey sick leave and their benefit year. Unions typically have a more favorable plan in terms of their collective bargaining agreement. However, they may negotiate for something different. That is up to them, and they can still include something separately as a title of New Jersey sick leave. Employees' attendance at activities such as sports events may qualify if the attendance at the event is requested by the school. There's lots going on for our kids right now. We're not really anticipating a lot of sports activities. Every district is doing what they feel is best for their kids. But going forward in the future, you may see some of these requests come through. When we look at the Diane B. Allen Equal Pay Act, the most significant one was Parado versus Morgan that came up and actually got into court. What was determined was that the Equal Pay Act is not retroactive. It cannot go prior to July 1, 2018. So when we had talked about this to begin with, when it became active, our conversation was about how it's part of NJ-LAD, about how it's part of the Equal Pay Act to begin with, and the fact that you should review your red flag staff, for example, folks who left under difficult circumstances, folks who could have made the argument that they were being paid significantly differently based on someone who was doing the same, if not equal work. So now we know it's not retroactive past July 1st, 2018. The past is the past, and we're going to leave it there. Some of the critical points, though, that we're seeing is that these equity studies that are coming as a way of proving that you're doing the right thing need to happen. And my suggestion is they happen prior to an audit or prior to someone making a claim. You want to include HR, finance, IT, and for you guys, your BAs, folks at a personnel level that can support the decision making. For many of the government entities, you're really covered with this because of your collective bargaining agreements. The problem for your folks is if you have someone who's in the collective bargaining agreement and someone who's outside of the collective bargaining agreement, and they are doing very similar work, the person inside the collective bargaining agreement could make a complaint if the person outside is making a different rate. The person outside cannot complain about a collective bargaining agreement. That is what the state prefers. That is what is supposed to be one of our safe havens in terms of this act. The Social Security tax withholding. If I had a nickel for every phone call I've gotten for this in the last 2 weeks, I'd be a millionaire. It was implemented September 1st. It is a temporary suspension of the 6.2% funding that you collect from the employee and pay to their Social Security. It's in effect until December 31, 2020. The employer then has to recollect and pay the funds back between, and that's a typo there, my apologies, January 1, 2021 and April 30th, 2021. See, 2020 is not really going to end for me at this rate. This does not appear to be good, shall I say, for many different entities, specifically in the governmental area, and it is optional for the staff. They can choose to do it. The recommendation and what I have grown to understand from civil service is they're not very keen on this at this point and think that it could be problematic going forward. Now we're going to move into our paid family leave laws, and these are what are currently available to an employee to utilize, okay? So the care for oneself, we always have New Jersey sick leave now, the temporary disability, workman's compensation, unemployment, and of course, for the moment, the FFRCA. Caring for others is a different set of items. You've got New Jersey sick leave. In the state of New Jersey, you've got family leave insurance, and then again, the FFRCA. These come and play on each other, especially right now. Traditionally, your personnel departments have seen it where the care for self starts the ball. You know, someone is pregnant, someone is going to have surgery, these items that come up for us as humans. As soon as that, for example, with birth and maternity leave, we get to a point and now your part-time disability or your temporary disability has expired. Well, with a child, now you move on to the FLI part of the experience. And now you've got a much longer period of time that an individual can take off legitimately for this reason. We know that there is an expanded rule on this, especially if it comes to the military and someone caring for an active duty or National Guardsman who has had, a trauma, a wound, etc. We have not tested all of this just yet with COVID, and some of the tests that have occurred where someone has started off for themselves and then moved into care for others has been either the two items have been separated, so it's care for self and then that person potentially goes back to work, and then the second person, the spouse, the child, whomever, is cared for by someone else or in a different venue. I have not seen anywhere it goes through like the maternity leave option, but that doesn't mean it's not going to occur. When we look at leave management, we've got lots of buckets that go into an absence from work. The very first thing that most courts will look at is, what does your personnel policy say? Yes, you have a collective bargaining agreement. That is, that stands. However, if your policy says we're going to do this for A, then you are going to do it for everybody, not just A. And we also need to look at, because we're really nice people, and what has your practice been? What have you been doing? If Bob gets to leave every Friday for a half day because he comes in early 3 days a week, well, if Bob wants to take off on a Friday, how many hours does he get charged? Are you charging the whole day? Or are you giving him the whole day? What is occurring with similarly situated employees? So now I want to come in early and I want to be able to leave early on a Friday. We've already done it for one. You're going to end up doing it for all if you're not careful. So you've really got to look at your policies and then what have your standard practices been? The statutory entitlements are items that we have specific law about, and they are requirements. FMLA during this current time of COVID has been very difficult. There are many governmental agencies who did not charge FMLA to employees who were out as a result of COVID. Now, as long as they kept their job for them, that's fine. But you can't get to the end of the experience and say, sorry, we had to replace you because you weren't here, unless your standards are clear that they were on FMLA and they've exhausted that FMLA. I'm seeing lots of conversation about that and NJFLA also. Folks trying to, as we were talking about, folks figuring out how not to work. There's a lot with the FMLA and NJFLA and spreading out that time. Part of the difficulty you will see with this is that a lot of the thought process was this was going to be spring and summer, and now we're seeing a continuation. All of your agencies have done a variety of different things, everything from an AB, week 1, week 3 schedule, week 2, week 4 schedule, to every other day, to, someone taking time and leave, some furloughing folks, every Friday is a furlough day. We've got to be very careful that we've documented the reasons for this. And I know you're all finance folks. However, after this, walk down to the personnel person's office and say, hey, I just watched this webinar. Let's chat for a minute, because these items are dramatically going to affect budgets. Because for some, you're going to have to find people to temporarily do their jobs while they're out. And for others, it's going to be, well, I now need, as of September, this time to care for fill in the blank. Where you start to see trouble is as a person exhausts one of their leaves, then that person, because they're all really smart and they all start to text message. As soon as one figures it out, everyone's going to get that text message. They're going to start to look at the ADA. They're going to look at NJ LAD. It's going to be, well, I now have a condition as a result of COVID or care or fill in the blank there. And so you have to be very careful before you start separating employees about what was their circumstances. So the income replacement considerations are sometimes throwing a dart at a wall. You have the absence from work. We've got to look at the reason for the absence of work. If someone legitimately presents that they have something that should be covered by FMLA, the organization identifies that and says, thank you for coming and telling us you're having surgery. Here's your FMLA packet. Please complete it. There are things where employees will say, oh, I don't need to file for that, or I don't need that, because they're going to take sick time. You can't operate that way. We want to be within the law. We want to protect our employees as well as protect ourselves and make sure that we're covering all the bases. Obviously, if someone gets hurt at work, they're going to go to workman's comp. If they're injured outside of work, potentially disability. Sick time is absolutely a possibility, especially when it comes to government entities. Care for a family member, we've got, family leave insurance. If there is a true break in service, they're going to unemployment. It's a question of what is the correct direction for this person based on what their issue is. I hope you've all seen this. This is the COVID-19 scenarios, and I'm happy to send this out to everyone if you did not receive it. As a matter of fact, I'll put it this way so I can make it a bit bigger for you. Some of the things that are here are things that we've got to really prepare for. Originally, when this document first came out from the state, an employee unable to work because they must care for their children at home due to coronavirus was fully paid across the board. They have changed that since then. A worker who's caring for a family member, meaning they are going to be isolated, they've been diagnosed, there's suspicion of, there are steps to protect them. The FMLA part in this situation that relates to COVID is only the childcare issue. If you look here, you'll see nothing else is getting FMLA from COVID. They can have FMLA just for care of self or for illness. So they didn't need to add this into FMLA. When we look at a person is out of work because their employer voluntarily closed, the folks that work for you when you closed, for our organization, we were all put off site, March 20th. We didn't close, but we all began to work in other areas, physically our homes. If we had closed voluntarily, I would have been eligible to go and get unemployment insurance because my job closed, okay? For the majority of you, you went off site who could, and who could not made other arrangements, right? So we put our safety practices in. We all know OSHA, we were paying attention to that. So you will see on this chart a variety of ways that an employee can have time as well as potential income during their time off. We're getting questions. Would anybody like to, I guess we could look at some of those now if you like. I don't seem to have access to it.
I could read them for you.
Oh, sure, that'd be great.
Okay. From Fabiana, we have, are per diem employees eligible to New Jersey sick leave, talking about building inspectors, judges, etc. We have some employees that get paid salary to get the job done and do not keep track of their hours worked since they are salaried. So the exempt employees and the per diem employees.
Yes, so per diem employees are eligible unless they were in a hospital setting. Everyone else that is a per diem style employee is eligible, and you would need to track the hours. My thought process is, though, correct me if I'm wrong, the judge is the judge, and that person's not full-time. They're not necessarily going to call out sick when they're working 1 or 2 days a week to be in the office, shall I say.
The next question's from Bill Homa. He wants to know, how does an employee pay Social Security back if he leaves the job at year end? This is the
this is the one where the alligators are at your toes, because they might not pay it back. And that's where there isn't guidance on this yet, and that is making lots of folks very wary of it. If the job ends December 31, that employee technically would need to pay it into the federal government at that point, especially if they're separated from you.
If you know they're
Problem.
If you know they're leaving, can you grab the whole thing on the last check?
And does that put them in a financial stress? You know, this is one of the reasons why we're not seeing a lot of folks jump at that opportunity.
Okay. All right. If an employee, oh, wait a minute. I'm sorry.
Yeah.
I might have deleted one. I'm sorry if I deleted some. All right. From Donna Kondo, we have, if an employee takes FMLA to care for a family member and is being paid by the family member, is that still considered FMLA?
So that's a different situation. The reality is that the employee can accept payment from that family member, but that would mean that they now need to consider themselves as a contractor and pay the taxes and so forth for themselves, because now they're accepting outside work. Obviously, I would think most people would be under the table, and it would be so that that person can care for them and they're able to continue to sustain their life at that point.
Okay. Oh, wow. Questions are starting to roll in. Tell me if you want to stop and get back to the presentation. Is the employer required to defer the Social Security?
If the employee wants to do it, yes, you would be required to defer the Social Security. However, 2 of my clients have said they're not offering it, that it is not an option for the employee to choose.
I agree with your clients.
Yeah.
That's why I'm not asking for legal opinion on that.
Yeah, it's a dangerous place to go right now in this day and age.
As a part-time employee being terminated, can I become a consultant performing the same duties if they are trying to institute furloughs and layoffs? Is there a waiting period?
So I have seen folks leave an organization and literally turn around the following week, and now they're a consultant to the organization. Where you run into trouble is, how are they paying you? If they are continuing to pay you through payroll, you're still an employee. That hasn't changed. There are folks, I actually just had a conversation this morning with a client, and they had furloughed the payroll manager, but they were going to allow her to have access to the payroll system so she could still run payroll. And that is a huge issue. Any of you who know your GAAP principles and have met the IRS at any stage know that that's a no-no. And I highly recommended they take away her credentials from being able to log into payroll. You can't do that. So contractor area is a gray zone, and it gets a lot of organizations into trouble.
This is really kind of a similar question. If I terminate a part-time employee and I furlough others, can I rehire the part-timer on a per diem basis if I need him?
Is it for the same job as the people you furloughed? That would be part of my question.
Yeah, I'm just reading the
A
question.
furlough
I just read
traditionally
that.
means you're coming back at some point. So one would need to be careful with that. However, a part-time employee is variable hour. You could potentially do it. Yes, I won't kid you. I won't lie. But as I said, as soon as things go on, the text message throughout all of the staff will be shared and someone will come up with a way around it.
It sounds like they want to furlough the employees and then hire temps to come back and do the work. So not sure if that's a good idea. Um, all right, there's two more in the queue because every time I answer one, another one comes on. So let's get through these two and then get back.
Mhm.
I read and our attorney confirmed that withholding Social Security is not necessary for the organization.
And I agree with them. Yes, absolutely. There are organizations that I was saying earlier that have put it in writing to their employees that this is not an option for them at this time.
Okay, last question. Per some of the information from the IRS and CPA classes, if an employee does not pay back the Social Security, the employer is responsible for paying it on the employee's behalf in first quarter 21. All Social Security not paid by the employee between 9/1 and 12/31 has to be paid at the end of first quarter 21. This is a terrible idea and I do not recommend it, especially for lower paid employees that will be killed by taxation after the holidays.
I don't know who wrote that, but I agree with you
Thank you
1000%.
for comment. All right, let's get back to the presentation. Oh, wait a minute. We have a poll question. Make sure everyone's awake and
Yeah.
paying attention. Does this workshop discuss the latest info on federal actions related to COVID-19? Yes or no? There are no right or wrong answers to these poll questions. Give them a second to do that while I clear this.
For the person who asked about the per diem is not replacing anyone else, then in theory you can bring them back as a per diem or a part-time, yes.
Okay. All right, no open questions and we did the poll. So let's get back to your presentation and I'll back off into the background.
So keep them coming. Questions are good and we all are still learning from a lot of this. The next item is workman's compensation. S2380 came out on the 14th. It changed the definition of essential workers. And why does that matter? Working for Prime Point, we do a third of the municipalities in the state of New Jersey. I love my municipalities. I love your personnel staff. I love lots of the finance staff. They're wonderful. Many of the staff that you have chosen to have in the office or to come in and fulfill their jobs during COVID would be eligible if they felt they got COVID while working away from home, meaning I came into the office. You know, the only place I go is the office and home, etc. So the definition of essential could mean lots of your employees. And we need to be very careful about that. We need to be careful as to how we phrase that for folks, especially since it's retroactive to March 9th. Essential employees are entitled to a rebuttal presumption that their contraction of the COVID-19 was work-related. And I say, you know, a nurse at a hospital can say, yes, I got COVID at a hospital. I work at the hospital. There's no guarantee of that. And that's where, you know, contact tracing was supposed to help us with that. Lots of folks don't like the contact tracing. Everybody's entitled to their opinion. But changing the definition of essential workers almost just made every single one of us eligible for workman's compensation under this current standard. I'm waiting to see if guidance comes out. I don't know when that will be if it does, but I'm happy to share it with you as soon as I get it. The state and I have had many a conversation, starting with New Jersey sick leave, so I'm all about getting answers from the right people. Now we got to work on managing our staff, okay? So, for example, my organization moved us all off-site March 20th. In order for them to do that, the 2 weeks prior, they were testing the system. They had folks testing the equipment in their homes. We had to test our Wi-Fi systems in our homes. Could it manage what we were doing? Many of our desks, quite honestly, look like the dashboard of the Starship Enterprise because of all the different systems that we operate at one point. So did we check, and are we checking now that all of our employees are able to do their whole job, whatever that might mean? Are your employee protections in place? PPE is not a suggestion. I went to the dentist recently, had to go in with PPE. They had more PPE on than I've seen, between shields, 2 face masks, 2 sets of gloves. There's a real risk in that line of work. There's a risk in your lines of work predominantly because you guys are so high customer service, you may not realize it or think of it that way. When I walk into our little town hall and I go to pay my taxes, I get to meet the wonderful lady behind the counter, and Miss Sue and I chat and we talk about my child. And, we're seeing these folks, lots of them live in your communities. We've got to ensure that our employees are safe and that they're being safe with the people coming in the door. There's an ongoing obligation, as we have seen now. And as of the moment, most of those obligations expire 12/31/2020. I'm not typically a betting woman. I only bet when I know I'm going to win. And I would bet you lunch that that's going to get an extension. We still see different states struggling with this as much as our state has managed it to a degree. I can't see December 31 being the end of it. Also because the flu is going to come, and that will confuse folks. Is the flu? Is it COVID? It was bad enough you had allergies and you sneezed or coughed and everybody backed away from you 20 feet. The next phase that we really got to be attentive to is documenting the employment conditions. We are a tech company. I was at my home for 2 weeks with all of my computer and all of the items, and I received an email from the director of operations who needed me to list every item I had in my house that was work related and their identifier, whatever it might be, the barcode, etc. Why? That's an asset, as all my finance folks, and they need to know who has what and what are they doing with it. And, it cannot be used for personal use. We know that people, if they are utilizing laptops from work or those kind of items, at some stage, they're going to check their bank account or they're going to go and look at their other personal email. We need to ensure that items come back to us in the condition we sent them home in, and that they have been well cared for and not drop kicked across the living room floor. The other piece to that is documenting how many days is this person in the office? Are they in the office every other day? You need to document that and put something in every single person's file. Yes, I know you're finance, but some of you manage people, and those people look to you as their manager to take care of them and support them. If you require, Susie Q to make a deposit every Friday, or someone to rec the bank records, they're coming into the building, don't rely on just a time clock that they came in. Make a note to yourself, was here this time, We've got to support our staff and be ready to answer questions when someone says, well, who was in the building that day? Because just because I clocked in doesn't mean I was physically in the building, right? There's a difference in finance and HR's work versus DPW folks. We now need to look at, wage and hour implications on the changing work arrangements. I have a client right now who has an employee who decided that it was acceptable to work from midnight to 3 a.m. because they couldn't sleep. And that person wants to get paid for those hours. And I know most of you are sitting at your desk or at a computer going, yeah, right, I'm not paying you. You may need to. And so we've got to make it very clear to staff, this is your work schedule. Yes, there are folks that you work with that their work schedule is going to be an on-call situation, all right? But in the job that I do here, it's not an on-call situation. Most of you are not an on-call situation. If you're calling me, the building should be on fire. And if you're calling me when the building's on fire, I can't help you anyway. but DPW folks, okay, tree service, all of the different things, because we're in fall, folks, I hate to say it, that are about to come with weather and so forth. Not that we haven't had enough crazy weather things over the summer, but those will impact us. And we've got to be sure that we can manage the employee and their work schedule versus what the expectation of their work schedule is. The last piece, of course, is the implementation of the COVID workplace policies. Plexiglass is at a minimum. If you can find it, congratulations, because it's not anywhere. We're still seeing Lysol wipes in Lysol, not in stores, or they're in stores and then 20 minutes later they're gone. There is a want, I'm thinking, as I've been staring at other folks, that, you know, people want to prep again and they want to get 6 things of toilet paper and 11 things of Lysol wipes. That's great, but if we're all not using it, then all we're going to do is end up sharing it anyway. You've got to ensure that your building is safe. You've got to ensure that you're thinking beyond what your normal routine is. I had a presentation 2 weeks ago, and one of the big things that we ended up talking about as a professional group was that things you do in your everyday become furniture. You don't trip over your furniture at home. You know where you put it. It's right there. It's always been there. You're not going to trip over it. Just like your habit of, I grab the door handle, I open the door. Do we have someone cleaning all the door handles? At this stage, I would hope so. But there's other surfaces and there's other things that might not be in your everyday, but are in someone else's everyday. And we've got to collectively go, oh yeah, we need to do this. Oh, did we forget? You know, in our town, we have a big festival that comes up in the fall. Well, we're not having that. And we've got to communicate those things, especially through our township, because our township is one of the reasons we have the festival. So there's lots of opportunity in there to look at the workplace safety pieces and share with each other. I'm sure you're going to have a program, or if you haven't already had one on that. So where are we at right now? Well, we're still at stage 2. We've got masks and gloves. We're doing 6-foot distancing. You've got special circumstances. You have folks who may have medical issues that do not want to be physically in your building, but they can do their job somewhere else, and that's okay. We can make that work. With the FFCRA, how many of your folks have used time? Who's tracking that time? Are you expecting a time clock to track it? Are you expecting their portal to track it? Are they putting it in employee experience? Are they handing in paper? Are they signing off for it? Are they emailing their boss? Who's doing that? And then what's going to be next? Because there's changes coming with the FFCRA that are going to change our workforce again. The 4 big changes that just recently came out is that the explanation for the requirement that employees may take FFCRA leave only if work would otherwise be available to them. Meaning, if I have work for you to do, but your child is off from school, you're sick, someone else is sick in your household, then you can take FFCRA. If you're already furloughed, if you don't work for us during this season, you're not eligible for FFRCA. It's eligible to a working person who is currently on your payroll being paid. If you are going as a parent, you need intermittent leave. That has to be approved by your organization. Now, I'm sure everyone will make whatever, ability to make those things work for people, but you still need to approve it because everything's going to roll back up eventually. All of this time that folks are taking is going to roll up to someone's audit trail. As we all know, the state of New Jersey is going to audit at some stage. They're going to come. That's what they do. That's their job. So the next piece is that what is a healthcare provider? And so we've got, those who provide diagnostic services, preventative services, treatment services. We went from, I'm a healthcare provider, which means I could be a rescue squad worker, which many of you are under the umbrella of your township or town. I could be a fireman, right? So now we're looking at folks who weren't officially titled a healthcare provider. Now they are. okay? And so we've got to be mindful of that. I think there's at least 2 of the townships that I know that have a hospital or a senior facility that have staff that are going to qualify for that. Excuse me. And then the last part is you've got to clarify with your staff what is the required documentation you want. In the early stages of this, in our area, when folks would go to have a test done, they were getting a document when they rolled through and had the test, and that it was a receipt of a sort. Within a month or 2 of discussing that with some colleagues, not everybody was doing that. Not everybody gave you a receipt that said, yes, I've just been tested. I need to be quarantined for 2 weeks. So we've now got to define, one, we're going to need documentation, and much like New Jersey sick leave, the employee can get it to you when it's practical, when they can get it. If they're sick in the hospital, don't expect a phone call. Don't expect any documentation. Maybe if you're lucky, a spouse or someone else will call you, but there's no guarantee of that. We've got another question. Are we going to wait for questions? Okay, I guess we will. So for school closures now, which is a different entity now, if school is physically closed and not in person at all, an employee can request to take FFRCA. If a school is hybrid, okay, in our town, we're a hybrid. The kids are in school Monday, Wednesday, Tuesday, Thursday, and every other Friday. They're alternating. The employee can request FFRCA intermittently if approved by the employer. If school is in full-time session, which lots of your towns are, and I'm so jealous, I really think the kids need to go back and they really miss each other and it's really hard. You cannot apply for FFRCA. If that school's open, fear is not a reason on the list of items that you can request FFRCA. And this is hitting some folks like a ton of bricks because the assumption was the kids are going back into school. I'll be able to take time. I'll be able to do intermittent. I can be home every other day. I can work from home every other day. That's not what's going on. When we look at our remote workers, one of the big things that we talk about is reasonable accommodations. And this is tough. I have seen 2 clients at this point where working from home is the reasonable accommodation. And I find that to be very difficult. We've already talked about the overtime potential issue. Now we got to talk about performance management. How do we know people are doing their job? Again, we're a tech company. Our cybersecurity team can look at my computer at any time. They're really going to be bored. There's lots of HR stuff going on and they're not going to enjoy it. Do you have that ability? Do you need that ability? Are there staff that are questionable that they can't work off site, because of whatever reason you may have? They physically can't do it. Mentally they can't do it. There are folks that mentally do not want to be in their home all day long. So those are some issues. When we look at this ADA accommodation, we always have to remember it's an interactive process. So for example, a person can come to you and say, look, I'm working from home. My back is killing me. I need a chair. All right. Okay, great. Take the chair out of the office. Take it home. Okay, great. Can do. Check the box. We have had our interactive process and we've agreed upon a way to fix this. Now I come in and I say, this chair's not working. I need a $1,500 chair that's ergonomic for my back. Yeah, no, not so much. Any accommodation that you make for someone can't damage the employer. So you got to think about that. There is an equation that most attorneys use to calculate whether or not something is considered damage to the employer. They're looking at salary. They're looking at quality of work. They're looking at potential work output. You're going to need support with that as well as that interactive process. So don't go it alone and don't just let the lawyer work on it. It is an interactive process and there's ways and means in there that we can work with things. You will have to be very mindful of disability discrimination cases. We know age discrimination. We have seen family discrimination, single person versus married person versus people with children. We have to be very careful of these discriminatory acts or issues. because what I may think is discriminatory, you may not, but that doesn't mean I'm not having an issue and we need to come to some working level together. So we've got some more questions. You ready, Jar?
Yes, I am. And I apologize. I started reading the question and didn't realize I was muted.
No
Uh,
worries.
so we'll try to get through a couple of these. That one is not a question, but reciting advice. I'll skip that. Are employers required to report FFCRA earnings on employee W-2s and on 941s?
Right now, I have no idea. I would tell you that we know there's going to be reporting required, much like your 1095s for ACA. I haven't seen anything in a draft form yet that shows that. You may know more than I do about it. And if you do know, email me. I'd like to know what they're saying.
Well, here's a statement from anonymous attendee. Also, I have read that on the employee's W-2 is going to have to reflect the amounts paid under FFCRA and possibly the expanded FMLA for childcare in box 14. I hope everybody has been tracking it.
Oh, whoever that is, I love you with the exclamation point, because you're right. I know they're going to want to track the child care issue, because the assumption was you needed to be home because your child care agency was closed. There are child care agencies that continue to charge people because you signed a contract with them. So you're going to really need to be on top of that with your reporting, and the parent is going to need to be honest about it.
Okay. Does FFRCA apply if the parent chooses to be 100% remote?
If the parent chooses to be 100% remote and the school is physically open for students to go into, you cannot receive FFRCA.
Okay, one more.
Okay.
If the employee is staying home for a child with closed school, does the employee qualify for up to 80 hours of sick leave and then the 12 weeks of 2/3 pay?
So if you take the 80 hours of sick leave, that's part of the FMLA, that's your first 2 weeks. Then you only have 10 weeks left at the 2/3 pay, up to $200 a day.
Okay, so it's not stacked. It's
Right.
concurrent. Okay. Not sure what square chain means. I'm going to dismiss that. All right. Well, we're running up to, we got about a minute left, but that's okay. Wait a minute. There's another couple questions.
Okay.
We got 2 minutes left, so we can field them. We're having our building, finance, and customer service employees keep timesheets like professionals with details of what work is being done. We found that makes much easier to manage what is actually being done. Okay.
That's a great idea. You want to have those details, and it's good for the employee to be able to prove what work they're accomplishing, and it's good for you to see it. It always helps in that relationship process.
Okay, and the last one. So if the school is remote 3 days and in person 2, and you choose not to send them, are they eligible?
You are not eligible if that child doesn't physically go into a building.
Okay.
So if they're supposed to be in 2 days a week, that's the only time that you would be able to get that FFRCA, is if they're physically in the building 2 days a week. The other 3 days you could take as intermittent leave.
Okay, and the time is up, and the next question would really require maybe 10 minutes or so.
It really doesn't. Hold on one sec. The way it works with COVID-19 is if you, quote unquote, catch COVID at your workplace or while you are working away from home, you are eligible to apply for workman's compensation retroactively to March 9th.
Okay.
Hope that answers it. If it doesn't, please feel free to email me. I'm happy to chat.
Okay. Are we still there?
I am.
All right. I just, my screen went wacky. All right. New technology to all of us. We've been surviving it, though. I want to thank Judy for an excellent presentation. A lot of good, well, I don't want to say a lot of good stuff, a lot of important stuff that benefits us. So I thank you again. And for everyone else, I'll see you guys in another 10 minutes. All right. Bye.
Alrighty, thanks.